Every winter, the Koch brothers conservative activist network holds its marquee fundraising event in Palm Springs, California. ProPublica reports that the network often rents out an entire hotel for the event, keeping out eavesdroppers, and that documents left behind are methodically shredded. They really do not want people knowing what's going on in there. Today, ProPublica reports that Justice Thomas has attended Koch's fundraising events at least twice, including the one in Palm Springs. According to ProPublica, donors typically have to give at least $100,000 a year to get invited to the event. Quote, those who give in the millions receive special treatment, including dinners with Charles Koch and high-profile guests. ProPublica confirmed that Thomas has attended at least one of those dinners as a speaker. Justice Thomas was the fundraising draw this time. A spokesperson for the Koch network told ProPublica that Thomas wasn't present for fundraising conversations, but one former Koch network fundraising staffer put it this way, quote, offering a high-level donor the experience of meeting with someone like that, that's huge, end quote. It's particularly huge when you consider that just 2 years ago, one of the Koch network's groups was the plaintiff in a Supreme Court case about the ability for nonprofit groups to keep their donors secret. And Justice Thomas ruled in the Koch group's favor just a few years after he attended one of the network's secret fundraising events. Justice Thomas did not, once again, respond to ProPublica's request for comment on any of this. And the Supreme Court does not have a written ethics code. They essentially police themselves, or not. That's the problem. I'm joined now by Dahlia Lithwick, senior editor at Slate, host of the Amicus podcast, and author of the book Lady Justice, which is a fantastic book, and it's now out in paperback. Dahlia, good to see you. If this weren't actually serious and about our Supreme Court, it's ludicrous.
It's ludicrous at every level.
Yeah.
And it's the kind of numbing effect of, it was funny with the glacier martinis. It was funny when, Sam Alito was holding the big salmon.
Yep.
And we all realized, Sam Alito is the salmon, right? He's the trophy here.
Right.
Same thing.
Right. And that's right. So there's this interesting line in the world that the Supreme Court is having some trouble with right now. And it is this: what's a gift? What's socializing? What's influence peddling? What's helping people raise money? What's drawing donors who then subscribe to or give to political causes? All of this is getting muddied, and we have no system to govern how it's supposed to go. We have just assumed that people who hold these august roles would govern themselves through the lens of propriety.
Right. And you don't have to think back all that far. 1969, Abe Fortas took, pennies compared to what Clarence Thomas and Justice Alito have taken, and was run off the court by his own colleagues, including the liberal Chief Justice, Earl Warren, who said, you are making us look bad.
Right.
And I don't even care that I'm appointed by a Democrat and you're appointed by a Democrat. I don't care.
Right.
You have to be gone. And that was understood. And the court ran him out for much lesser offense. So here we are now, and we've got Chief Justice John Roberts doubling down, saying, Congress can't touch us. I don't have to show up and testify.
Yep.
And we
don't have to answer it to anybody. ProPublica is just a journalism outlet, but they don't have to tell anybody anything.
And Justice Alito, who gives an interview
Yep.
To the Wall Street Journal in which he asserts that Congress has no authority over the
Yes.
court. So, that's where we are.
So let's discuss that for a second, because when he said that, I sort of went, obviously to my Constitution and tried to make sense of this. Our co-equal branches of government are supposed to be co-equal and independent of one another. But we have mechanisms. They have been flawed over the last few years, including our impeachment mechanism for the President of the United States. But there are mechanisms. Was there never one for the Supreme Court? What was meant to happen if the Supreme Court justices get involved in untoward behavior ethically?
Some version of what happened, I think, to Justice Fortas, which is the court said to themselves, we have neither the power of the purse nor the sword. We only have public legitimacy. If the American people want to just ignore our rulings, they can. If Congress wants to just turn off the lights, they can. So let's conduct ourselves as though we are above reproach. Mm-hmm. And the other piece of this that I think is really heartbreaking is that the same justices who are saying that, government sucks and the CDC sucks, and that's the heart of the Chevron doctrine, right? We're going to cripple the administrative state, are the ones who don't care about the legitimacy of their own branch. So how can you keep harping on how bad government is without kind of looking at your own house?
Let's talk about the Chevron doctrine for a moment. This is something that Justice Thomas is involved in. Senator Dick Durbin has asked him to recuse himself from an upcoming case. There are a lot. I know you've talked about it a lot today. There are a lot of people who don't know what the Chevron doctrine is, but it has to do with our agencies of government and what authority they have. People will have heard this discussion about the dismantling of the administrative state. It's definitely the kind of thing that folks who don't think about this a lot could glaze over on, but it's actually really important in this particular context.
Right. I mean, this is any agency under Chevron. This is a case from 1984, and it seemed an uncontroversial principle.
Like when we talk about agencies, CDC, EPA, anything like that.
Any agency, if there is something written that is ambiguous, the court says in Chevron, defer to the agency's own reading of the statute. That makes sense, right? Because we can't, what are we going to do? Send every question up to the court?
Right.
Justice Thomas was for the Chevron doctrine until suddenly he wasn't. And Justice Thomas is an interesting character because he doesn't change his mind very often.
Right.
And so he went from being a very bold supporter of the notion that, of course, we let agencies construe their own statutes to, not so much anymore. And that doesn't happen very much when you're Clarence Thomas. And I am in no way suggesting that hanging out with the Koch brothers, who have spent decades trying to dismantle the Chevron doctrine and thus dismantle the regulatory state so they can pollute and so they can do all the things they want to do. I'm not saying...
But it looks messy. At this point,
it looks awful.
And I think this is important to understand for folks who don't follow the Chevron doctrine. This idea of the administrative state, whether you think about it much or not, if you are really rich or you're a company that wants to throw your garbage into the river or burn your smokestacks, you don't want regulation. Now, there are some conservatives who legitimately just they're not into much regulation. They don't want government to regulate much. But in this particular case, there are lots of places with particular interests to want these government agencies to be weakened.
Exactly right. And in the last few years, we've seen the EPA, the Clean Water Act dismantled. We've seen President Biden's student loan forgiveness, all done under the rubric of this large theory that you don't want government bureaucrats controlling your life. It's a basic libertarian principle. But we can't function as a society if we don't have agencies that are making sure that workers are protected, that health is protected, that the environment is protected. And so, in effect, what you're looking at is an effort to say, all bets are off, no regulations, no administrative state. And again, I think the cynicism of saying government is bad, government is bad, government is bad, when your own court is a hot, steaming mess. Is
right. So you're separating the issues. In other words, there may be a debate to be had. It started largely with Ronald Reagan, who came out and sort of said, I'm going to dismantle all the stuff that was really, that had been built up through the 30s and the 40s, the big government, all the things that government did. We're going to now try and make small government. It started with that. That can be a valid debate that people can have in different fora. The issue is, if the Supreme Court has to make decisions, and that is where these decisions come about whether the EPA has power over something or any given agency does, then we'd like to know that the Supreme Court justices are squeaky clean on the issue, that they will have no relationship to anybody who may have an interest before the court or an interest in the dismantling of the administrative state.
That, and the people who should be making decisions about clean water are experts and scientists and people who have studied it their whole lives, and not Justice Alito spitballing about what he thinks environmental policy should be. I mean, the whole point of having an administrative state is that you people it with experts and scientists and facts. And we have seen this move at the Supreme Court in the last couple of terms, where the court arrogates unto itself more and more and more power to decide issues. And I guess we're both landing at the exact same depressing place, which is a Supreme Court that is going to seize power from state courts and from the executive branch and from the federal government should be squeaky clean.
Yeah, and it's not feeling all that squeaky clean today. Nice to see you again. As always, thank you for this.
Thank you.
Dahlia Lithwick. And her book, Lady Justice, is now out in paperback. I had the privilege of talking to Dahlia about it when it first came out. If you haven't picked up a copy, read it. It's really important.